Good morning to all the experts in the road freight industry, and welcome to this joint venture between the Road Freight Association and CDH. And may I at the outset just thank Gavin and his team, Chantal, and on our side, the business development people, Theo sitting next to me, and Cheryl for making this possible. As you would know, that there's a long relationship between us and the road freight industry, I think, and probably I was going to say since 1922 or just shortly after the Normandy invasion, but it's not that long. I've been doing employment law probably since 1922 or a bit longer, and I've sat on the bench from time to time. So I'm just really here to share stories and share with you some sort of case scenarios that you would ordinarily not find in textbooks, and hopefully we can learn from that. You will see on the document that we will present and that we will make available to you that there's a reference to an S in red, which is with a reference to strategies which I think we should consider for your industry should you have a strike. And when I talk about strikes, I mean protected and unprotected strikes. Because at the moment, given the development in terms of the wage negotiations, it's unlikely that we will have a wage strike. But certainly, despite that, we will continue to experience unprotected strikes in our industry, as we would see in every other industry. So I'm really just going to share with you stories, etc. If you have any questions, you're most welcome to simply post that on the chat line, and Theo sitting next to me will refer that to me, and we will, in all likelihood, just respond to that in writing. We have about an hour and 15 minutes before we start taking questions. If you have any input to make, I see a lot of familiar names on the screen, Henny and all of those, any input from your side, most welcome anytime, etc. So the idea is, when we deal with today's session, is not to have a formal presentation on strikes and lockouts. I'm assuming that you have the basic knowledge, but as I've said, we're going to focus on stories and we're going to focus on strategies. Now, when we talk employment law, I'm going to start really by just referring you to some sort of some of our experiences and stories in this industry. We need to think out of the box. And unless we do that, we will not survive this scenario of conflict within the workplace, and one that's sometimes sabotaged by discontent and distrust between the parties. And I'm talking management and labor. So let's just as an outset share three stories around unprotected strikes and protected strikes. And by simply thinking out of the box, you may or may not prevent a strike. So the first one that I want to share with you, and these cases are reported, so I can share it with you, and there's a matter, say, where I was personally involved in. And the first one is in Ford, the motor company, the auto manufacturing company. Now, what happened in their particular matter is that, as you would know, there's a dispute of interest, and if there's a dispute of interest, the matter is referred to the CSMA, and if there's a certificate of outcome issued, or in the ordinary course at least, then people could embark on a strike by giving 48 hours notice. Now, in the Ford scenario, they had the historical differentiation between the monthly paid and the hourly paid. Now, nowadays, you have the distinction between Patterson grading or Parometer's gradings, whatever the case might be. But those were the two categories, and they experienced a high rate of absenteeism in the, I can't recall if it was East London or Port Elizabeth branch or factory, and they then put in a rule in place which says that the employees must produce a medical certificate for every day of absence, and that applied only to the hourly paid employees. The monthly paid remained the same. You must produce a medical certificate after 2 days of absence and subject to the normal requirements of Section 22 and 23 of the Basic Conditions of Employment Act. So what happened is that the hourly paid employees were obviously upset about this differentiation and distinction. They declared a dispute. This dispute was caged in a manner where it said we wanted to be treated the same as the monthly paid. In other words, we don't want to produce a medical certificate for every day of absence. We also want, similar to the monthly paid, a 2-day arrangement, similar to 22 and 23 of the Basic Conditions of Employment Act. So what happened in that particular case, they deferred the matter, the dispute could not be resolved, and there was a certificate of outcome, and then Ford received a notice of a strike. And of course, as we know, no strike is ever convenient, and I was instructed to consider ways to prevent a strike. So what we did in that particular matter is that when we received the notice of the strike, we look at the demand. And as I stated, the demand was the hourly paid employees wanted to be treated the same as the monthly paid. So we then issued a notice overnight to all the monthly paids and said, in future, you will also be required to produce a medical certificate for every day of absence. So there's no more distinction between the hourly paid and the monthly paid. They all now treated the same, and the monthly paid, I'm repeating a bit, must also produce a medical certificate for every day of absence. So now the demand has effectively become ineffective because they now treat it the same as the monthly paid. And we've taken it, the distinction, we've withdrawn the distinction, and hence we approach the court on an urgent basis and say you can only strike if there's an alive dispute. Remember, a strike is about a withdrawal of labor on a collective basis, demand, and in respect of a matter of mutual interest. So what we did is we got rid of the demand, treated the same, and we successfully interdicted the union in that matter from taking their members out on a strike. So sometimes when you're faced with demands, just revisit those demands, and we're going to look at some of the strategies when you revisit demands from time to time, and some concessions you may or may not want to make, which may or may not be of any consequence to the company. So that's just thinking outside of the box. The second one is to utilize certain provisions in the Act, and there's a specific provision in the Act, Section 23, which allows for collective agreements which you enter with majority parties to be extended to non-majority parties, even unions. And in this particular case, this was in the media industry. The newspaper was going to run the particular Sunday, and we had a majority trade union. We reached an agreement on the Thursday with the majority trade union. The minority trade union by that time had already given us notice of a strike. They had a strike certificate, and they gave us notice of a strike. And what we then did is we invoked that Section 23 of the Labour Relations Act and put in a clause in the wage agreement that says this agreement will apply to all non-union members, and that's of the majority trade union, and extended the agreement to the union who's in dispute with us, or was in dispute with us. Now, we know in terms of Section 65, you can't strike if the issue in dispute is covered by a collective agreement. So what we then did, we approached the court and said, well, the strike will be unprotected because the minority union is now bound by the collective agreement, and hence they can't strike. So again, it's just utilizing provisions in the Act to prevent strike that would have been ordinarily protected. And the court again interdicted that strike. The third scenario that I want to share with you is the one that we often come across in a strike scenario. You have a strike, there's a mass dismissal, and as we know, when there's violence and there's a mass dismissal, you will always struggle to identify each culprit, and there would inevitably be a risk of inconsistency. And what will happen is that you will overlook people, or people were wrongly identified. And what the unions would typically do is when you go to arbitration, then they will raise that as a matter of inconsistency. And we know that inconsistencies generally create a huge challenge for management. Fortunately, the case law says that it's fair that employers may be expected, or it's normally in a strike scenario where people would not be able to identify all people who transgressed, etc. So this is a matter in the casino industry where we had this sort of violent strike. The people were identified, some were not identified for obvious reasons. And what then happened is that when we went to arbitration about 8 months later, the union raised the point of inconsistency, and we said, well, look at the case law, the SAPI fine papers, and all of those. It says you must identify and tell us who those people are, and put that in writing. They gave us the name of 2 people, and we said thank you. The management went back to the offices. They gave notice to those employees of a disciplinary hearing, and they got dismissed. And when we revisited the proceedings the next time around, the union said, well, they want to issue more names with regard to inconsistency. And the commissioner said, have you not learned your lesson? What's happening here? And the union decided not to pursue that. But again, you can use a scenario which is adverse, but use it to your advantage by just really thinking out of the box and doing what we think is probably common sense to do. So that being said, let's talk about and I'm going to take you through certain slides and just talk through that generally, and as I've indicated, we'll take some questions throughout or at the end of the presentation. Theo here will tell me when we have any of those. Good. Can I just make the last point before we move into that, is that we're currently operating in our industry, that is the transport industry, within the scope of a bargaining council. And we know that those bargaining council agreements, wage agreements that is, would be for 1 or 3 years, and we've recently signed 5-year agreements in some mining companies, that for the duration of that strike, employees can't strike over issues that's embodied in the agreement, and we'll come back to that a bit later. But the importance of this is the following, is that if you don't have centralized bargaining, as we have in our industry, each company, each transport company may be faced with bargaining at plant level, and one must be wary of that and whether that is possible for you, logistically speaking, to manage, as opposed to have centralized bargaining. Right, so let's just move to the first slide, and we're now just going to talk about vulnerability, because whether the strike is protected or unprotected, the first point of departure is for us as employers to consider our vulnerability with regard to the strike. And as I've said, whether the strike is protected or unprotected, that's inevitably those factors, and even more than those, you need to consider. Now, the first one is obviously stock. In our terms, it means client product. What product are we moving? Sometimes we're moving essential services type of product and delivered it to hospitals, sometimes not, but we don't necessarily fall within the ambit of an essential service. So not that it always matters, but people may not strike in those industries. But be that as it may, there's a strike, and then those are factors to be considered. What are the client's demands? And often we know in our industry is that clients have little sympathy for our labor unrest, and they simply give us notice and say, you must sort this out, and if you don't, we will give this contract to another company. So critical that you liaise with client, that we determine that vulnerability, and of course, the first issue that you will consider is bringing in replacement labor. Fortunately, we're not in the position, as in the chemical industry, for instance, where it's virtually impossible to bring in replacement labor in terms of truck drivers because of the expertise and knowledge. And you would ordinarily have a list of retrenchees whom you can call back to replace the people on strike. Of course, with that risk is embodied the access to the workplace, because we know that if the workplace is blocked, then it's impossible to bring in replacement labor, even if you bring them in at the back gate or otherwise, but it creates a problem and a challenge. And hence, your reference to the SAPS is critical, and you should have the station commander or the region area commander's name on your speed dial list so that you can liaise with them immediately. Our experience is generally that unions, the police, are not really helpful, but we've seen that case coming from the northern province, Limpopo province, where an employer successfully sued the police because they didn't intervene and do their jobs. And that went to the Labour Appeal Court and the High Court, and the employer was successful in claiming damages from the police. Of course, we need the police on our side, and that relationship is critical, because when you have this sort of scenario, when you have replacement labor and you can't bring them in, then your hands are tied, and the employers have the power of the strike, whether it's protected or unprotected. May I just also make this point that when you deal with a protected strike, and I very seldom come across that scenario, but when you can bring in replacement labor and you can sit out a strike, whether it's protected or unprotected, that's in most cases your most effective mechanism of defending and breaking. I'm saying you should break the union's back, but you know, when you have an unprotected strike like that, you don't have the ideal relationship in any event. But if you can set out a strike, that is ideal. You ignore the union, you ignore all demands, but provided you can manage business, you can manage violence, and you will have to consider community involvement. Because we often know, for those of you that operate out of Richards Bay and those areas, where there's one central point or one road leading from the different communities to the workplaces. And once the community is involved and support the strike, then it becomes impossible to manage, because you can't get workers in, whether it's as a TS or not. So community involvement, critical. Union participation, as we know that if you have different unions, you can potentially divide and rule and the like, but be wary of that. Workplaces, I just made a note here. If you operate within a business park, it also creates challenges, because in those places where most other employees in that area would also be affected, and you would have a few enemies that you don't necessarily want. Violence, I've addressed. Security, we all have security on standby, but just be wary that you must caution the security people to act with the necessary caution, because that may eventually attract some sort of liability, directly or indirectly, during a strike. So those are just points of departure when you deal with vulnerability, and strategies when you are faced with a strike. Good. I've alluded to this earlier. Just always remember there are three elements to a strike. There's a collective withdrawal of labor. In other words, more than one employee must participate, irrespective of their egos. How big that is, it must be more than one. There must be a demand, and it must be in respect of a matter of mutual interest. It can't be a political demand, i.e., let's imprison all the political leaders in our country. Maybe you don't want to impose that, but assume you have that sort of demand, that would be an unlawful demand. It must be a matter of mutual interest. In other words, something that the employer can do, can change in the employment relationship. Always remember the purpose of a strike, in particular a protected strike, is there to hurt the employer financially, because there's an entrenched right in the Constitution protecting the right to strike, Section 23(2) of the Constitution. Right, so let's just go back one step, the definition of a strike, unpack demands. When you receive those demands, when you receive the letter of communication from the union making those demands, then it's critical that you unpack those demands, because often part of those demands are unlawful or are prohibited, i.e. you have a wage agreement in place, as we would have a collective agreement operating for a period of time, and there's a demand for an increase in wages, and it's often comes about from unions that are not part of the collective bargaining scene within the road freight industry. They want to obtain more members. As we know, unions is about a business. They need members to pay for the Johnny Walkers, which the union leaders have in Sandton and the like, and hence it's about money. So be wary that you may have the minority trade unions outside the bargaining council that will come in and make demands also reflecting on wages. And of course, they can't do that because of the provisions of the Act. Is there some way we can delete this messages that come in? Just ask Andrea if she can. Good. So just remember, when we unpack the demands, you will go back to the record and you will, please don't. Just clear this. Clear that. Good. So unpack those demands and you look at the first letter of demand. In particular, you look at the 711 or the referral of the dispute, because that will be indicative of the nature of the demand and the lawfulness of the demand or otherwise. But look at the type of demand. Sometimes you have a demand simply for the dismissal of a manager. Of course, that is an unlawful demand. You can't ask the employer to do something that's contrary to the provisions of the Act. That is an unlawful demand. Sometimes it's impossible to accede to a demand, i.e. It is with regard to socio-economic issues, such as an increase in bread prices, etc. I mean, that falls under the socio-economic sort of protest action. Sometimes the strike is prohibited, as I've indicated. That's where the issue and dispute is covered by wage demand, and it's covered by the collective agreement. So you can't have that. And the last one is outside a matter of mutual interest. You sometimes have political parties getting involved in strikes such as the EFF, and I brought the first application of that nature in the country, where we, the Callahan Lounge case, where we interdicted the EFF to become involved in employment relationships. And the case law is clear on that. There's no space for them in the employment sphere. Be wary when you have the EFF, and I'm using that by way of example because that's the group that we mostly come across. They sometimes have people in their red t-shirts and berets, etc. And when you do a letter to the head office, they pretend to have no knowledge of these people and they have no authority to do so. So it's critical that you identify those people, get that letter out to the EFF, and if they disassociate, you can go on social media and otherwise to consider who may or may not be members of the EFF. And the courts have seen through that, and they're likely to assist you in granting you an interdict when you deal with the political interference at the workplace. Right, let's just quickly catch up on protected and unprotected strikes. The question is always, is a strike protected or unprotected? Of course, they are similar to a dismissal. There are two requirements for a protected strike. One is procedure, that's your section 64. In other words, there must be a dispute, and the dispute must be referred to the bargaining council or the CCMA, and there must be a certificate issued, or after 30 days, employees acquire the right to strike. And that is the procedure in terms of section 64. Section 65 is the substantive clause, similar to a dismissal, and that is where you, even if you have a certificate, you may not strike if the strike is prohibited. And whether the strike is unlawful or whether it's simply prohibited in terms of section 65. So we can just park that. I assume you have that knowledge, and I'm not going to delve into that. What I want to look at is the issues in terms of procedure. And the first one is the refusal to bargain. Now, remember, a refusal to bargain could be a dispute about bargaining levels, bargaining topics, bargaining units, etc. But just remember, when that is the issue and dispute, there must be an advisory award before they can strike. So consider that. Often people think that when there's a certificate of outcome, which is incorrectly issued, then people can go and strike. But if the demand is about a refusal to bargain, it falls within that category, you can effectively interdict that strike. And as we know in strike law, a strike delayed is a strike denied. So it's often useful to interdict a strike because they've not obtained an advisory award, and then the strike is delayed for that purpose. And again, it gives you more time to plan, etc. So just consider refusal to bargain. The other topic that we come across a lot is this unilateral change to conditions of employment, or an alleged unilateral change to conditions of employment. And what we know the law says is that if there's a unilateral change to conditions of employment, then the union will refer the dispute, and unless you revert to the status quo within 48 hours, the people can go on strike. They don't have to wait for the 30 days for the conciliation, etc., provided they have picketing rules in place. The importance of this is to look at your contract of employment, and the lesson is always to allow for maximum flexibility in your contract of employment. I don't see that enough in our industry and in other industries. You need maximum flexibility. And the clause that they would often strike about is you want to change the shift system, or you want to change some form of hours of work, etc., because clients' requirements change, or you obtain a new contract from a new supplier or a new client, and now there are different requirements in terms of delivery, different hours, different shifts, etc. And then the unions would object and say this is a unilateral change to conditions of employment. They give you notice, and then they think they can rely on this 48-hour clause to get to a strike. It's important that you draw the distinction between conditions of employment and work practices, because if we do that, and the matter involves only issues such as shift changes or work practices, then you can interdict that strike and say it's not a change to conditions of employment. And again, you can effectively stop the strike on that basis. And many of you would know that there's so many reported cases where we've done that in the past. But again, it breaks the back of that union and that demand, because the strike will then be stopped and you can proceed to implement your new shift system or hours of work. The last point that I just want to alert you to is this issue of the content of a strike notice. Don't just accept if they've complied with the procedure, i.e. the referral to the bargaining council or the CCMA, there's a strike certificate, there's no provision of the strike, etc., that they can just on notice go on strike. The case law is quite clear, and that old beta sanitary, what was that case? Sanitary ware case has to a certain extent been overridden by the Constitutional Court. But the point is that when you receive that notice of a strike, it should at least set out the demands. In what they would ordinarily do is just refer to or attach the issue and dispute, and there must be at least 48 hours notice, and that 48 hours notice can run over a weekend, unfortunately. But of course you should have, if you have a relationship agreement with the union, it's an agreement. This is just another tip. If you have a recognition agreement, you have an agreement that notices of a strike will not be given, for instance, over weekends or over public holidays. Because we know what would ordinarily happen. You would get that notice of a strike the Friday afternoon. It goes to a fax number that's not necessarily in use anymore. And the Monday morning you arrive at work and people go out on strike. So put those provisions in your recognition agreements or collective agreements or relationship agreement, doesn't matter what you call it, in order to prevent these surprises. But the point I want to make is when you get that notice of a strike, consider the content and see if it complies with the minimum provisions of the Act. The beta sanitary ware judgment also said you must state the exact time of the commencement of the strike. That's not a requirement anymore, sadly, in terms of that Constitutional Court judgment. So just be wary when you deal with a protected strike and you think everything is in place, consider what the content of the strike notice says. I've dealt with flexibilities, unions, positions, and let's move on to protected strikes or still unprotected strikes and the procedure. Of course, we now know that when you deal with procedure, if we can go to the next one, Theo, we will see that picketing rules must be in place. Now, the answer here lies in, again, a strike delayed is a strike denied. Historically, what we did, you will recall that once there's a notice of a strike, the unions didn't want to come to the party to sit and negotiate picketing rules because they preferred to have the strike without rules. Now that law has changed. We had the formal introduction of 69 and 69.5 in particular, 6, and we have the developments in terms of the rules of this CCMA. So what is now required is you need a picketing agreement in place before people may strike. Now, how does that benefit the employer? Well, first of all, you will have rules that will assist you to govern the strike. But more importantly, there's a clause in section 69.6 which says who must be present when you set those picketing rules. And it says the owners or controllers of the property or the workplace must be present when you set those picketing rules in place. Now, it's a reported case, so I can just again share with you. In the Dis-Chem case, we had over 100 of owners of properties and from throughout the country when we set the picketing rules, because they sat in shopping centres, and all those owners and controllers of those property where they rented from had to be part of those negotiations. Now, that creates an opportunity for you to delay a strike, because what will happen is that you will get a notice of the conciliation, and then the union or the commissioner wants to proceed immediately with setting the picketing rules. But then you will rent your property, for instance, where you operate from. And then, of course, the landlord or the owners of that property would not be present, and they can't set picketing rules without their presence. And you will raise that as a point in limine, and then the matter will be delayed so that those people could be properly notified and form part of your discussions. Also made 2 points here about the picketing rules, and look at the default picketing rules. It's clear, no dangerous weapons. I remember being in a matter where people said, but it's part of our traditional weapons. Unfortunately, the commissioner was on top of it, and he said, well, this isn't a traditional event, it's a strike, and hence you can't wear shields and as the guys and the like. Balaclavas, the story about that, I remember in a matter where people were gathering and there was a camera up here on the corner. It was in Wadeville, and we saw a group of people gathering here, legal strikers, and we saw one person walking to the back, put on a balaclava, and we saw him taking out a catapult, and we just saw him shooting towards the camera, and the camera went blank. Of course, it could be identified, and his defense, as we've seen in many of these cases, he said, well, they were in the third week of a strike. There was a pigeon sitting on the fence there, and he tried to hit the chicken because they were hungry and they thought they can bribe the chicken, the pigeon, and hence he had no intention to take out the camera. Of course, fortunately, the commissioner didn't accept that version. But of course, you now have the provision that no balaclavas, etc., so that where people are clearly identified, particularly when you deal with violent conduct. And in particular, when we're going to talk about common purpose and the principles of derivative misconduct. When you identify people, how do you identify people? And that mitigates the risk of inconsistent treatment during a strike. So let's just move on. I'll be as quick as I can. I've dealt with the extension of collective agreements in Section 23. Of course, there's a similar provision when you deal with bargaining council agreements under Section 32, where that agreement is then extended to non-parties and it's binding on them. In Section 23, it's really plant-level negotiations. And as I've explained to you earlier, in the media case where you can use it to your advantage. And remember, that also applies in a retrenchment scenario. And why? I know we're dealing with strikes, but it is an important tool to use. You often have a majority trade union at the workplace, and you may reach an agreement with the majority trade union about a particular retrenchment scenario, whether it's in terms of packages or otherwise, and there's a minority trade union that for some reason is obstructive. And then remember, when you deal with a large-scale retrenchment, they can also go on strike, or they can refer the matter to the Labour Court. You can even utilize Section 23 under those circumstances to say, this is the agreement with the majority trade union. Because it's a majority trade union, you put in a clause that says this agreement is extended to non-parties, including non-union members, and it's binding on them. And that would then mean that that minority trade union can't take you to court to attack the procedure or substance, if they can attack procedure, of the retrenchment. They can't go on strike because the issue and dispute is covered by a collective agreement. So never underestimate the value of Section 23. The next clause that is an important one, and you have one in your bargaining council agreement, that says for the duration of the strike, employees may not strike on the issues listed in the agreement, and it's with regard to substantive issues, and that is defined in the Act. So often you would have a demand, as I've alluded to earlier, about a wage increase, and you'll interdict on that basis. what I want us to do when we ever at plant level deal with a settlement agreement and it's not covered by the main agreement, you need to put a clause in place that's wide enough to protect you. And what we typically do in the non-bargaining council agreements, we put in a clause that says, for the duration of this agreement, and this is critical, for the duration of this agreement, i.e. 3 years or whatever, the union, including everybody covered in terms of this agreement, in other words, non-members and new members, etc., and old members, will not be entitled to refer a dispute in respect of any matter that sounds directly or indirectly in money. Why do we put in that clause? Because there's a new minority union on the block. They want new members, so they say, we're going to demand from the employer a share option scheme or a bonus scheme. It's not covered in the agreement, but it sounds in money. So if you have a proper no claims clause, you can interdict that strike. If you do not have a proper no claims clause, you can't interdict that strike, and that minority trade union can potentially take their members out on strike. So be wary of the provisions of those and your wording of your collective agreements when you, with regard to wages or otherwise. So that's the limitation. Secondary strikes, I really just want to make the point, on secondary strikes, section 62, there's 3 requirements. Firstly, the protected strike must be protected, the primary strike. Secondly, there must be 7 days notice. And thirdly, there must be a nexus between the primary and the secondary employer. In fact, section 66(2)(c) reads as follows. It says that the nature, and just listen to this wording, because this is the exact wording of the Act. It says the nature and extent, just check if I'm right, the nature and extent of the secondary strike must be reasonable in relation to the possible direct or indirect effect it may have on the business of the primary employer. Now, you could just pick up from that wording all those vague clauses and the risk of that. Fortunately, we've seen, you'll see I've given you cases in brackets, the Anglo Gold Ashanti case. You'll recall that was that long strike in the platinum industry, and then they gave notices of a secondary strike to the other employers. In our case, in the transport industry, it would, for instance, let's say you do a contract for Checkers, it may say, well, we're now going to give notice at Checkers of a secondary strike because there's a nexus between you and the secondary employer. Now, what happened in that case when it went to the High Court or the Constitutional Court, not sure it went to the Supreme Court of Appeal, be that as it might, Labour Appeal Court, the highest court in that case said that you look at what I've mentioned there, the proportionality test, but what it did look at, it said, let's look at the financial implications of that secondary strike. Let's look at the violence in the primary strike, which was rife, and to what extent you may have a repetition of that in the secondary strike. You as a union have shown that you can't control violence of your members, and hence the court interdicted the secondary strike. So on the face of it, you would ordinarily come across a secondary strike. It may look at it may, on the face of it, looks as if it qualifies for a secondary strike, but consider that Anglo-American case. What Theo will do for us at the end of the day, he'll take all those cases and give you the full reference of the cases and just send it to you. Good. Let's look at compliance with the Act, the next slide. And I'm just making a few notes there, again, about strategy and going forward, etc. And the first one is, of course, there's no work, no pay. Remember, that applies in a protected and unprotected strike. You often have unions telling their members that if it's a protected strike, you'll get paid. It's critical that we communicate that in a protected and unprotected strike, that there will be no payment. But let's look at the strike bonus. Now, you will recall that historically, the case law was against the employer. It says that you can't pay any form of strike bonus. It's an infringement of the right to strike. It's an infringement of the right to collective bargaining, and you're effectively victimizing non-union members with reference to Section 4 and 5 of the Act. So you've always had those challenges. So what happened in the Cullinan case is there was a bonus payable towards the end of the year, and there was a disqualification, or a so-called disqualification. The facts are a bit more complicated than that. And the union argued these points and said it's because of their participation in the strike. But the court did there, it gave the green light for some sort of, let's just call it strike bonus for the lack of a better word. But what I want us to consider when you have a strike, and I'm now talking about a protected strike, because an unprotected strike, you're free to reign within the ambit of the law. But when you deal with a protected strike, there's a provision under 187(1)(b) of the Act. That's your automatic unfair dismissal clause. And it says you may not dismiss a non-striker who refuses to do the work of a striker. That will be an automatic unfair dismissal, and we know that carries a 24 months max compensation clause. My sense is that it would be perfectly admissible for you to enter into an agreement with the non-strikers and say, I want you to do extra work for i.e. the work of the people on strike. And for that, I'll pay you an additional amount. So there's no bonus. There's a simple contract for payment of additional work. And in that way, you can potentially look at it. There's no case law on it, but that's something that the courts will in time, if people apply that strategy, will test. But I remember at the old e-school that still today there are targets set that people still cannot achieve till today in terms of production outputs during a strike by non-strikers. But of course, the reality is that it's not sustainable. People can't carry on working the extra hours, etc., and their safety and the like. And in our transport industry, it's of particular importance because our trucks are on the road. I've made here a point. The law says you can't dismiss striking employees, of course, unless it's for violent conduct and unless it's for operational requirements. Operational requirements you can ignore because it's virtually impossible for dismiss for that because of the duration. If you have a large-scale retrenchment, it'll take you 60 days to consult and 30 days for notice, and by that time, the strike should be over. And in any event, at the end of the day, if you must then still pay severance pay, that'll kill the company. But of course, we know that you don't have to pay severance pay because you'll say, I'm making you a reasonable alternative offer, i.e. come back on the new wages and conditions of employment. It's a reasonable offer, and if you've not accepted that, you will forfeit severance pay. But be wary that you can still dismiss for violent conduct, and we're going to focus on that a bit later. Right, let's talk about unprotected strikes because that's in the order of the day, and we're just going to talk about a few of your remedies there and just touch on some of those. Now, we know that ordinarily you're bringing an interdict, or you may consider bringing an interdict, and you would ordinarily have your lawyers drafting papers, and then you get the interdict, which is fairly simple to achieve. Sadly, you have to give 48 hours notice. Unless there's violence, it's difficult to get a shorter than a 48-hour date from the court, although depending on which court, Joburg or Cape Town, you will get a shorter notice. And then you interdict, and there's an interim order, and there's a final order. Now, companies don't do that, or lawyers don't ordinarily do that, but what I want us to consider, and we've effectively used this effectively, is that we put in a clause in that interdict and in the court order that says the union must, within 3 days after this order, file an affidavit to court to show how they've ensured compliance with this order. In other words, and you will give directions, you'll communicate by SMS to your members, and here's a standard notice which you will put in your notice of motion and court order, which you will issue as a union to all your members, and other means to dissuade your members from participating in the strike. And why is this so important? It places a huge onus on the union, but more importantly, remember at the end of the day, and I'm not saying here to punish unions, but you may want to go for a contempt of court order, which is quite effective. And if you have that sort of provision in your interdict, you can later utilize that to bring a contempt of court application, in particular where you can show that that order was served and there was non-compliance of the order, and of course you had certain damages. And we've seen the court issuing contempt of court orders, etc., against unions. Of course, it also impacts on if you claim compensation against the union. Remember, it's not a damages clause, it's a Section 68 clause, but still that will be a factor to be considered by the court in granting you compensation. But critically speaking, in that interdict, put in that in your notice of motion and your draft court order, that clause that forces the union to show and to satisfy the court that they've done everything in their endeavors to ensure compliance with the Act or with the court order. Identify culprits. You will recall that historically when you have an unprotected strike, it's quite simple. You bring an application, you say the strike is unprotected, and you attach Annex A. These are the list of all people participating in the strike. That's still fine. However, sometimes you bring a strike purely based on violent conduct. And just be wary of the developments in law here that when you want to do that, the courts will require you to identify the culprits and take action against them. And what you will then do is you will attach the list of those culprits, you'll attach the photos, and you'll identify all of them to ensure that the court will grant an order against those particular individuals that causes damage, or whatever the individuals that may cause damages or otherwise. So be wary of that. Identify the culprits. That's because of the Oak Valley case. Suspension of picketing, and may I just share with you again our experience in terms of that. In the Dis-Chem strike, when we set the picketing rules, the union was exceptionally obstructive. As I've said, there were hundreds of employers involved, or owners. And when the union stopped participating and left the room, they said, and it was recorded, "We're telling you this strike will be violent." And what happened is that in that particular case, for the first time in our country, we were able to bring an application to court to say, well, first of all, we interdicted their violent conduct, and they didn't they didn't stop that. And then we brought an application to suspend the picketing. Now, we know that when the picketing is suspended, then that by doing so, the union loses all power. And in that particular case, we were successful, and that court order was confirmed by Van Niekerk later. The first judgment was by Snyman. It was confirmed later by Van Niekerk with costs against the union. But the point is, you're not without remedy. If there's a continuous violent conduct and people ignore court orders, bring that application to suspend the picketing. Of course, the question is still whether you can bring an application, and that case was not being decided, to stop a strike, to say this strike is not conducive to collective bargaining. If you look at the demands and how it's changed, it's now become a political strike, etc. But that case will still have to be decided. But if you look at the Chogo Sun, it's potentially possible to bring that, but then you must be brave enough for it. The next item is about dismissals. We can dismiss, and I'm talking about an unprotected strike for people participating in the strike. And be wary of item 6 in Schedule 8 of the Act, which says you must involve the union. The ultimatums must allow for sufficient time to respond and reflect on the ultimatums, etc. And you see that I refer to collective hearing, and that's a Steve Spar case, which says that you can have collective hearings. But what Steve Spar also says, in your ultimatum, you should have at least 2 clauses. One is, we say the strike is unprotected. You're invited to say before this time whether you say the strike is protected and the reasons for so. Second, we intend to dismiss your members. Tell us before this time why we shouldn't dismiss them. And according to the Steve Spar case, that complies with the OD Ultrim. But I think the more practical, and this is, I think, trade law, all of you know this by now. The Samankle case is the one that I want us to consider our ultimatums. And what happened in the Samankle case, they issued ultimatums. It's a reported case, those ultimatums were not well worded, but ultimately people returned to work, and then they dismissed people who participated in this unprotected strike. And often you have that scenario. You have people already on final written warnings. They now participate in a further unprotected strike, and now you issue ultimatums and you dismiss them. What is critical for us as employers is that we put in that ultimatum, we reserve the right to discipline people who participate in this unprotected strike, even if you return to work. Now, I know that isn't a great clause because it may act as a further deterrent for people to return to work. But unless you have that clause, and that Samankle case went to the Labour Appeal Court, unless you have that clause in your final or in your ultimatum, it will be difficult for you, because of that judgment, to then take action against employees who return to work. Because sometimes we know this is a scenario. There's an unprotected strike. It's incited by a particular individual. People return to work. You have that clause and you issue a final warning to everybody who participated in the unprotected strike, and you bring in a catch-all clause so that you ensure that people who were on leave, etc., weren't issued with final ultimatums. 2 weeks later, you've now done your investigation. Now you suspend the culprit, the person who incited the unprotected strike, and you will in all likelihood have another strike. So it's useful by that time to already have your final written warning, a valid one, in place, so that you can then proceed with dismissal. But the point is, we can only do that if there's protection in the ultimatums. And we know that as employers, we should have a list of ultimatums. It should be readily available that we can just amend from time to time, depending on the circumstances of the case. In your ultimatums, always stipulate what is the issue in this demand, what is the issue in dispute, what is the demand, and what is the company's response to that. Because guaranteed, if this matter goes to court in 2 years' time, there will be a list of other demands that they say they really went on strike about, and it's nothing to do with what transpired on that particular day. Unions can become quite creative when they go to court, and it's important that we quite aware of that. Next page, lockout. Just take note that if it's an unprotected strike and you lock out your employees, you don't need to give 48 hours notice. It's not necessary. Replacement labor, we've covered that. Now you can bring in replacement labor. And then of contempt of court, just remember the test for contempt of court is beyond reasonable doubt, and it's not on the balance of probabilities. But contempt of court, we've addressed that, and it's quite a strategic tool to use. What I've done here on the last page, and I'm wary of the time, we will try and finish at about 15:15 so that we can discuss anything that you like. Other considerations, other strategies that you may or may not consider during strikes, the like, and I've listed a few here. Counter demands. So often we go into wage negotiations without considering what are our needs as an employer. What do we need to change? Where do we need more flexibility? And I must actually send you that one-pager, Theo, just make a note of that, where I think we need to change our conditions of employment to make it more flexible and to build in prerogatives and to build in easier and smoother processes to dismiss, etc. But the same here, when you have conditions of employment that does not work for you, that do not work for you, then ensure that you put those in as counter demands so that you can address that. But when we deal with strikes and lockouts, and I'm now going to deal with the practical issues. You've had a strike, was a violent strike. There are two notices that you should issue, whether it's a protected or an unprotected strike, before it commences. And the one relates to common purpose and the other one to derivative misconduct. And let's just discuss those two principles. Derivative misconduct is really an onus placed on employees to disclose the misconduct of fellow employees where they're aware of that. And the case law is quite clear on it when you deal with derivative misconduct, that there's a duty on employees to disclose that, and if they don't do that, they can be dismissed for it. Now, we know it's a difficult scenario because you have the Impimpi scenario at plant level where people are reluctant to disclose, and it may sometimes feel unfair to take action against them. But be wary of that principle. When that matter, the Dunlop matter, where there was violence, etc., people didn't disclose and they were present, saw on video the conduct of fellow employees, they didn't disclose that, and they were then dismissed not only for their participation in this unprotected strike, or where the strike was protected, for the failing to report. So that is derivative misconduct. Common purpose is where you associate yourself with the conduct of your fellow with the fellow employees causing damage and violent behavior, as we've seen in Marley Pipes. And we're going to come back to that. But the point is, the common law, common purpose doctrine is part of our employment law, and you can dismiss people when they associate themselves with the conduct, with the violent conduct of fellow employees. And that's what happened in Marley Pipes. There was a manager it was an HR manager, just for those that are HR managers, increase your insurance. And that particular manager was assaulted, and there were about 40 odd people who were not part of that assault and weren't present, but they were also dismissed based on this principle of common purpose. And of course, that matter went to the Concord, and it was set aside, and the court relied on a criminal law judgment to say these are the requirements when you deal with common purpose. And Theo, will you share this with the team as well? But this just with reference to the case law, the criminal case law, the court said people must be present. If you want to rely on the principle of common purpose, people must be present at the scene of violence. People must be aware of that violence. People must have intention to make common course with the bad violence, and must have manifested the sharing of the common purpose. And of course, they must have had in the criminal law also the intent to foresee the possibility of this misconduct taking place. So be wary of the principle of common purpose. And again, going back to the two principles, before the strike, you will issue a notice to the employees and say, we're a responsible employer. We're duty bound to protect you as an employer and to ensure a safe work environment. We appreciate the people's right to participate in a strike, if it's a protected strike. And we respect their entrenched rights. However, given our duty towards our employee, we remind that there is also a duty on you towards the employer to disclose the misconduct of fellow employees. If you do not do that, please take note that that itself constitutes a dismissible offence. And then in terms of that Dunlop case that went to the Concord, you must give an insurance and some sort of assurance. And your assurance would be, if you disclose that information, we will protect your identity. And I'm going to come back to in-camera case evidence. So what happened in Dunlop, in derivative misconduct, the court accepted that principle. It says there is a duty on that employee to disclose. However, the court said it's a reciprocal duty. The employer must ensure the safety of its employees when they make that disclosure. And hence, in that letter and in that invite to your employees, you will provide for that provision of security of identity. Because in fairness, you wouldn't disclose the names of fellow employees who misbehave if you know you or your family might be at risk. But the point is, it acts as a further deterrent for people to embark on violent conduct. And again, it gives some sort of protection to employees who would then come forward and disclose. So that is derivative misconduct. It is important that you cover yourselves in advance. Now, the same with the common purpose principle. You may or may not have that embodied in that same derivative misconduct letter, or you may have a separate letter to say that we're telling you in advance that if people misbehave and they commit some form of violence and you're present, you're not only duty bound to disclose it, but you need to disassociate yourself from that. And if you don't, we're going to make an adverse inference and you may be dismissed for the principle of common purpose. So very carefully worded letter, because what you want to do is you want to lay a basis for that case that will later come. And remember, every letter, every ultimatum becomes an annexure in court papers. Every communication to the trade union, be careful what we say and how we say it. What we said, and I'm repeating on the ultimatums, those become annexes in court papers, and 2 years or 10 years later, the court will analyze and reconsider at their leisure on your conduct, that your action that you took within 10 minutes and had to take critical decisions. then the courts will have ample time to be critical about your conduct. So walk the extra mile, protect yourself, and let's continue to do that as employers when we face protected or unprotected strikes. I mentioned the principle of in-camera evidence, and why do I refer to that? Because we've seen in all cases where there's a strike that people are reluctant to come forward, and we appreciate the rationale and the reasons for that. Is there a question, Theo? Please put your questions on the WhatsApps. If there's anything, Theo will try and show it to me, or we will address it in correspondence later. But let's deal with, and incidentally, this Deelkraal case that I'm referring you to is a matter that was dealt with by Larry Shear. Many of you may know him, the short chap that is an ex-old industrial court president and is now was a commissioner at the CCMA. And he dealt with this Deelkraal case on how do you deal with evidence in camera. And we've used that a couple of times with many of you. And these are the principles when you deal with in-camera evidence. In other words, evidence that will be led where the witness will not, his or her identity will not be disclosed. And how do we do that? So how do we set that up? Ordinarily, you would have a hearing at one venue, and there will be a separate venue within the same town, workplace, or at a different place, even sometimes in a different town. And what you will then have is you will, with that, have the first venue, you will have the company representatives and everybody present. At the other venue, you will have the chairperson and maybe somebody from HR and the particular employee that requires to give his or her evidence in camera. And they'll sit separately. That identity will never be disclosed. But in order to do it more effectively, you also need voice distorters. And I've often seen people when they're reluctant to come forward and give evidence, that once you show them how their voices are distorted, that creates confidence. So in your preparation, you'll show them how it works and play their voice, and it sounds like a Mickey Mouse voice, but it gives them that confidence that their identity will not be disclosed. But can I just share with you, then sometimes we take, as employers, all the precautionary measures, and nobody will know who the witnesses will be. And then you'll have a supervisor saying to the group of people, you there, you want to give evidence, go, management wants to see you. And of course, the identity of the person will be disclosed. So the whole process must be treated on a confidential basis, be that as it may. What's the test? How do we satisfy the court that we're entitled to bring in evidence in camera? There are two stages. First of all, you will have to lead a witness that did either the investigation, or your HR guy or your head of security that would deal with the strike violence. Did that in a recent matter of Omnia, Asma, Charlie and myself. And what we did is we called that witness, and the witness set the scene. There were houses set alight. There were cars set alight. There were many complaints. We had many complaints of people coming forward. We say, this is what we're saying, but we're not going to give evidence because of fear of life and threat and all of that. So you'll set the scene, an objective scene, for showing the necessity to call people in camera, witnesses in camera. Then the second stage is now the subjective test, where you deal with this particular employee. And that also has two phases. One is the employee must show real fear, i.e. family and what they've seen and what they've experienced, family members being, or fellow employees being attacked. And secondly, show that subjective fear. And for instance, in this case, we had one employee that said, when this happened, they visited my home, and I then had to relocate my family, and they now live with the in-laws, etc. Maybe that's a way out. With the in-laws, etc. And hence, I have a real fear of my life. And once those requirements are satisfied, then the commissioner or the chairperson will say, you can have that evidence, lead that evidence in camera. Now, remember, we do it either at the hearing in plant, at plant level, or when the matter goes to the CCMA, you'll again apply for evidence to be led in camera. But it's important that you could comply with those Deelkraal principles with regard to the objective and the subjective test before you're entitled to bring in witnesses in camera. It's an expensive exercise, but it creates trust. And we've seen ultimately sometimes when you get the real culprits out, the remainder of the employees will come forward and say, thank you, now at least we can come and work at peace and we're not intimidated. Because there are, unfortunately, people whose interest isn't the same or aligned with yours, and you need to manage that. Technology is the next heading, and I'm just simply mentioning it because in the Oak Valley case, the court said you have all the technology at your disposal. You have cameras, etc. So it's easy for you to identify culprits. So hence the point I made earlier, when you bring the application and it's about people conducting themselves in an unacceptable manner, that you will identify them, you put on the photos, you make the videos available to court, etc. And you'll depict and identify those people causing a problem. Ballots. Now remember, there are two types of ballots. Unions are ordinary, or they may be required in terms of their constitution or otherwise, to have ballots before they can take their members out on a strike. And we know in terms of section 67(7), if they don't do that, you can't use that as a basis to interdict the strike. I'm not talking about that. Sometimes your information is that your employees are comfortable to accept your demand, but there's one particular union member or union official, and there's a hardliner, and there's a relationship problem, and they use the strike for their own benefit. And my sense is this is a useful tool that you would then communicate to your people, because you have the email, we have their WhatsApp numbers or their telephone numbers, mobile numbers, and you then conduct your own ballot on a protected basis and a secret basis, secret ballot, where you say whether they're in favor of the strike or not. But it's useful about that. Once you have that information, it's a useful tool to then sit with the union and say, I've embarked on this ballot, and it shows that you don't have a support for the strike. Not that the union will stop from doing that, but we know that the strike may then be shorter, and secondly, the union may be at risk of losing their members. And what you will then do is you will communicate to people, these are the offers we've made, because remember, the unions don't always communicate their final offer from the employer, and you will put that in communication, you will support that by the outcome of the ballot, and it's often a useful tool that employers do not use. I can't see the last... inconsistencies in dismissal. I've shared that information with you in terms of the casino case, where you can even later dismiss, but except when the courts have accepted that when we dismiss a number of people during strike violence, the courts have accepted. One is, as long as they can't show mala fides, in other words, that you've identified a particular person because you don't like them. But once you can show that you've acted in a bona fide manner, it's okay. The courts have accepted that you may oversee and not see all the misplaced or misidentify some people. You may even not have identified people who were seriously misbehaved because you had no witnesses to come forward and identify them. So it's twofold. Either you've not identified, it's not come forward in terms of derivative misconduct, or you've identified the wrong person. The point is the courts have accepted that when you deal with inconsistencies, that in a strike context, you may make such mistakes. So don't go to court and they point out inconsistency and you think it's the end of your matter. It's not the end of our matter. Look at the case law. It's there to support us. I didn't touch on the point as who may participate in the strike, and that is important because that's in contrast with who you may lock out. Now remember that the law says, section 23 of the Constitution says there's an entrenched right to strike, 23(2), I think, C. So what the courts have done is they've looked at, from the Plascon decorative case up to the Malotho Sun. You'll remember the aviation case. The courts analyze what do you do with people who fall outside the bargaining unit. In other words, managers that want to participate in the strike, or of other unions that's not declared a dispute, as in the Malotho case, can their members participate in the strike or not, called by this union? And the trend and the case law is certainly pointing towards the direction that everybody can participate in the strike. I'm talking about the protected strike. Even members from outside the bargaining unit, even non-union members, even members from another union might participate in this strike declared by this union. So when you plan your strike, or when you anticipate a strike, do not just accept that you have a lot of non-union members and they can't strike. That's not the case. Or there's a lot of other unions who's positively inclined towards management and their members won't strike. Ultimately, there's group pressure, there's pressure in the communities, etc. If they go on strike, that will not constitute an unprotected strike and give you an opportunity to dismiss them, because that is what happened in the aviation cases, and those people were all reinstated. It's interesting, and I'm just mentioning it to you, that when you lock out, remember there's a right to strike in the Constitution, but only a recourse to a lockout. When there's a dispute with the union and you lock out their members, you can't lock out non-members or other union members. The Patco case says that there's a limited application or interpretation of the right or the recourse to a lockout. And unfortunately, your right there, or our rights as employers, are limited when we deal with the lockout scenario. So just be wary of that. The last point is just the issue of social media. I don't think we use that enough, but certainly there's scope to use social media and otherwise to communicate to our employees, in particular during strikes, not only on social media, but using WhatsApps, etc., where you will convey to your members and show them, you've now been on day 5 of your strike, you've already lost out on so much wages, etc. I remember I sat in a huge meeting once with unions, and it was the officials and the employees. And I said, but the employees, do you know that when you go on strike, those officials are getting paid? Of course, I was in huge trouble for saying that, but that was the truth. Well, that is the truth. Because the union officials who organize the strike, and I'm not saying they should not be paid, but they sit in their offices, they organize the strike, and they're getting paid. It's the employees who will suffer the consequences of a protected or an unprotected strike in terms of no pay. So do we have any particular question or that we need to?
Not yet.
May I just, because we have a few minutes left, just going to go through clauses which I think that you should revisit in terms of your contract of employment. One is, we will share that with the group. Do not incorporate in terms of your contract of employment your policies and procedures. Because the moment you incorporate it, you must negotiate changes in policies and procedures. So do not incorporate that in your contract of employment. 2, put in that all relevant information was disclosed in your CV and in the interview, and be very specific. We have a standard clause that says, is there anything that you did not disclose? If it becomes public knowledge later, will be a potential harmful or whatever, you can use different words, will cause some sort of reputational damage to you or the company if it's disclosed later. So put in that catch-all clause so that if people lie on their CV, as we often see, or misrepresent why they were dismissed or left their previous employer, that you can dismiss them, even if you've not asked them whether you've had previous dismissals or not. You will put in this clause, a general clause, anything that you're aware of that may cause some sort of discomfort, whatever wording you want to use. I think it's useful that we put in layoff clauses in terms of our contracts of employment. I said so many years ago, in particular when we saw Eskom rising or disappearing, we will say that if I can't utilize your services for any reason, then there's no duty on me to pay you. Of course, it's subject to bargaining council agreements. And why do we put that in the contract? Because the principle of force majeure is not wide enough to cover the scenario where the employee is totally innocent, as you may have. So have those clauses. It's not being tested, but we'll see where it takes us. Incidentally, you know, the force majeure cases came from the so-called Crown cases in England, where it was Elizabeth's mom, dad's name, King, whatever, And what happened is he was going to do a parade in Regent Street. People rented balconies to watch him, and he became ill. Remember, he smoked a lot. He became ill and couldn't participate, or couldn't do the Regent Street parade. And then people claimed their monies back from the landlords that they paid for sitting on the balconies, and they said, well, this was force majeure. And that's where the principle was started in the South African, borrowed in the South African law. Put in clauses that you have the right to amend your contract of employers in respect of all flexibility clauses. Put in a clause to simplify probation and particular management dismissals that says, item 4 says, you'll be notified of the charges, you'll be given sufficient evidence, you'll be invited to make a response in writing, to be represented by a fellow employee. That will be put before an independent chairperson. The independent chairperson will make a finding and may call upon witnesses if necessary. I like those clauses because we're spending too much time, the CCMA and otherwise, in defending in particular probationary dismissals and executive dismissals. I think you can also provide for that in your other contracts of employment, but it's more difficult to do so because of union involvement. Put in clauses the right to transfer your employees, because often you don't have that, and you have a transfer, a business is transferred, or there's a merger, and now you get arguments about payment for new allowances or traveling allowance, etc. Put in forfeit clauses in your contract of employment. If you don't give me notice, 14 days notice or 30 days notice, whatever the requirement, you will forfeit your leave pay that's outstanding, and that constitutes damages for the purpose of the Damages Act. And the reason why we put that in is in the old Basic Conditions of Employment Act, there was a clause that says you can set off any money is due in terms of leave if the employee doesn't give notice. Consent to lifestyle audit, I think it's an important clause to put in, and to have lifestyle audits, it's a useful tool to have, and you'll put that. Consent to polygraph test, because we know that people, if there's a polygraph test, you can't rely on the polygraph test to dismiss. It's only a supporting tool. But if you put it as a condition of employment and the employee refuses to undergo a polygraph, then you can dismiss for failing to comply with a reasonable instruction. Put in zero tolerance clauses in respect of safety and all of that. You're entitled to do that. Put in a derivative misconduct clause that says if people don't disclose it, they can be dismissed for that. Put in a clause that suspension pending any disciplinary inquiry can be without pay if the employee delays the procedures unreasonably. And we should put that in our codes and procedures, and you can do so because it's a policy document. Simplify hearings, and put in a clause lastly that the company may appeal the outcome of disciplinary hearings if you have that, because if you don't have that, then you have the so-called double jeopardy rules and all of those, and the case law that's generally going against the employer when you're faced with a dismissal, with a non-dismissal of a serious misconduct by a manager, and your hands are tied. So we finished a bit earlier than anticipated. I must really thank you all for your participation and just sharing. Hopefully there are questions that we'll get. We will send to you the document that we've worked on, the slides, as well as the case law. Please send us the 9-point clauses. So we'll send this one. We'll also send that to you, the ones that I've just read to you. And I think it's useful to consider that. Don't go into it blindfolded just because it's how you do it, but do it. So we'll do that. So from here on, how do I always close these sessions? I say, you're part of managing your business. It's about managing chaos, etc. Often. And like Love Mordenberger said about managing chaos, etc., it's manage it rationally, or it may happen chaotically. It's your choice. Thank you for your time, and thank you to Gavin and his team at the RFA and to our team here at CDH. Thank you for the long relationship we share with you guys, and I can't wish you a lot of labor unrest, so I should wish you a lot of labor peace. And again, thank you for participating this morning. It's much, much appreciated. Thank you.